Well, a guardianship and a conservatorship are both processes whereby a court will appoint an individual or an entity that has fiduciary powers to represent either an incapacitated person in the concept of a guardianship or a protected person in the context of a conservatorship. With respect to a guardianship, the person who is appointed by a court as guardian is responsible for care and custody of the ward. That's a legal term for the incapacitated person, the ward. And that care and custody can be as simple as taking the ward to doctor's appointments, determining whether the person is going to have in-home care or go to a continuing care facility. But essentially, guardian is responsible for the care and custody of the ward. A conservator, on the other hand, is responsible for managing the affairs, the assets and finances of the protected person. So a guardian is responsible for the care and custody of the person. A conservator is responsible for managing the assets and financial affairs of the person. How does the conservator and guardianship process get started? Great question. That gets started through a petition that is filed with a court. Generally, it is a state court, and it's generally where the person who is in need of a guardianship or conservatorship resides. And the person who is filing this petition needs to be an interested person. They either need to be a family member, or they can be someone that the individual has selected to make financial or medical decisions, either through a designation of guardian or conservator or through a durable power of attorney. Durable powers of attorney are tools that are designed to not make guardianships or conservatorships needed. It's a tool that can be used to substitute for a guardianship or conservatorship. So what clients may do is they may want to name a confidant or a friend or a family member. They may want those individuals to make financial decisions or care decisions on their behalf when that client becomes incapacitated. And the way we can do that is through these durable powers of attorney. Through these durable powers of attorney, the client will indicate who they want to serve as their agent to make financial decisions. Generally, that is referred to as a financial durable power of attorney or a general durable power of attorney. And on the medical side of things, the client can select who they want to make care or medical decisions on their behalf if they are incapacitated. Powers of attorney are definitely a great tool to avoid the initial need for a guardianship or conservatorship, but there are many shortcomings of powers of attorney. The one big shortcoming of a financial power of attorney that I have seen is that the agent does have a duty to keep accounts and keep tracks of records of receipts and disbursements, in the essence of accounting of their actions as financial power of attorney, but they're not required to disclose that accounting to the principals or the client's family. They definitely need to disclose that to the client upon reasonable request, but sometimes family members are very concerned that an agent may be overstepping the bounds or may be doing things that is not in the client's best interest or not what the client wants. And in that case, when the family tries to get information from the agent under the financial power of attorney, and that agent under the financial power of attorney refuses to give them that information, that the only recourse for the family is to actually go back to a conservatorship or a guardianship. Because what's nice about conservatorships and guardianships, while they do require court involvement, there is a requirement that the conservator and the guardian report, not only by filing reports with the court shortly after the initial appointment and also annually thereafter unless the court requires it earlier, but they also must report to interested parties. So family members that want to see what a person in charge of their loved one's finances is doing, through a conservatorship, they are going to get at least annual reports. Through an agency under a power of attorney, there may not be annual reporting. So that is one thing that comes very nicely through guardianship and conservatorships: transparency. So the one takeaway with conservatorships and guardianships is don't be afraid. They are not a bad thing, and in fact, they can be exactly what is right for a family because they do provide for more transparency and reporting than through use of powers of attorney.